Hi, I'm Rita Gupta from LGFL Limited, and this is another update in respect of the impact of coronavirus on family law. Specifically today I want to talk to you about court hearings. Now, if you've had a hearing listed for many months, you're awaiting an important outcome, or have invested a lot of time and money into a future court hearing, I can understand that it's a very anxious time for you. Earlier in the week we talked about what could potentially happen in respect of hearings moving forward. Now, yesterday, the President of the Family Division issued some guidance in respect of family court hearings. What's been said is that, of course, these are unprecedented times, but that it's in the public interest that the justice system, so far as possible, continues to operate. What it's been said is that, if at all possible, that hearings should be moved to a remote setting, so email, telephone, Skype or video conferencing. The guidance says that if it's not possible for the matter to be dealt with as a remote hearing, then the hearing should be adjourned but listed for a remote directions hearing, so that it can be ascertained how that we can move matters forward on a remote basis. What has been said is that if it is in the interest of the public for there to be an actual oral hearing, then that should take place so far as possible. What has been referred to is that the government's recommendations in relation to social distancing applies more in a social setting rather than a handful of people in a courtroom. I also think you need to consider that there will be local practices that will apply in respect of this matter, so things will be dealt with on a case-by-case basis. The types of court hearings that can be conducted in this way are, for example, public law proceedings, so they would be care proceedings. They could be private Children Act proceedings, injunction proceedings and financial remedy proceedings. So during this time, you need to be in touch with your family lawyer, if you are represented, to seek guidance as to how the local courts are dealing with such matters. For many courts, it's very much business as usual when it comes to the family law situation at the moment. There has to be a facility to record any remote hearings, and there is provision for e-bundles to be lodged with the court 24 hours before. So who's going to be responsible for setting up these electronic hearings? Well, if you're the applicant and you are legally represented, then it's your responsibility. If you are the respondent who's represented but the applicant is not, it's the respondent's responsibility. And if neither party are represented, then it would be the court's lead in relation to this. So it's almost like the bundle rules at the moment. But as stated, you do need to contact your local court and see what they are doing under these difficult times. Now, what I would say that the pressure on the justice system at the moment is going to be immense. I think for non-urgent applications there is a potential for postponement and delay. The court are going to have to prioritise urgent matters during this period. You also need to think about whether you should be taking your family lawyer's advice in respect of whether now is the right time to settle a case. Is a postponement right under your individual circumstances? This is all to be dealt with on a case-by-case basis. So whilst I understand that it's an unnerving period of time, and I've probably not given you a final answer in respect of matters, this is the current guidance, and what you need to do is contact your family lawyer, or if you're unrepresented, contact your local court who's listed the hearing to see what they're doing under these circumstances. As soon as I have any further updates, I'll provide them to you. Thank you. That's Rita Gupta from LGFL.